What does it mean when the defense refuses to mediate your case and they refuse to offer you a dime? Would you like to know what it means? Come join me for a walk through the neighborhood as I share with you the answers to those questions. I am Gerry Oginski, a New York medical malpractice and personal injury attorney. You brought a medical malpractice case or an accident case or even a wrongful death case. And now, during the course of your lawsuit, you were hoping and expecting that you could settle this case early without having to go to trial. You were hoping that you could settle this at the very beginning before your case even started. Then when that didn't happen, you were hopeful that your case would be settled shortly after your attorney started the case. That didn't happen. During the course of the litigation, now, throughout the next 2 years, you were expecting the defense to recognize that they did not have a valid case, and you expected them to make a substantial settlement offer and hopefully try and settle your case. Unfortunately, that didn't happen. So now, during the lawsuit, the defense tells your attorney they have no interest whatsoever in trying to negotiate your case. They believe that your case is defensible, meaning they believe that they have a strong defense and that you, on the other hand, do not have a valid or meritorious case. Your attorney relays that information to you and you are devastated. You are upset. In fact, you are angry. How could it possibly be that the defense doesn't understand that they have no valid defense? How could that possibly be? Likewise, the defense turns to your attorney and says, how is it possible that you have a valid case here? I don't get it. There's no liability here, they argue. And even if there is liability, that they're responsible, they argue that your damages are not as significant as you claim them to be. So now there's a problem. What's the problem? You believe you have a great case supported by medical experts. You believe that your case is worth a substantial amount of money because of all the damages and harms and losses you suffered. The defense, however, doesn't see it that way. They see it as, hey, this is a frivolous case, although they're not using that word. They're saying that your case does not have merit and that you do not have a good case, and therefore they are not going to negotiate with you at all. Now, I use the term mediate. What does that mean? Mediation is typically a private negotiation session that happens with a retired judge, assuming that both sides are willing to enter into settlement discussions. Now, instead of having one-on-one conversations with the attorneys, now the attorneys use an impartial mediator to try and facilitate and move this settlement negotiation forward. In that instance, both sides come to the table knowing and recognizing that they are both interested in trying to resolve the case. However, in this scenario I've given you at the beginning of this video, the defense has come to the conclusion that if you are going to trial, and if you do go to trial, that they will be successful in showing to a jury, 6 members of the community, that you are not more likely right than wrong, that what you are claiming is true. And if that's the case, the defense will get a verdict in their favor, and you, unfortunately, will not. So what does it really mean if the defense has no interest in trying to negotiate or mediate your case? In all likelihood, it means your case is going to trial. Now, there is a caveat there. There is a however. And the however is, they may come to their senses. The opposition, the defense, may turn around as you get very close to trial and say, you know what, we have reassessed and reevaluated this case. And now we believe that it's time to start negotiating. That is a possibility, and that does happen from time to time. So, why do I share this quick information with you? I share it with you to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.